Hi there, I'm attorney Kelly Longtin from Kelly Longtin Law, and today on this video, we're going to talk about things to consider when a parent is out of town. Now, your estate plan may include powers of attorney that allow a trusted person to act on your behalf and advocate for you with regard to medical and financial matters when you cannot do so yourself. But do you have a similar document in place that gives someone the authority to care for your minor children when you're not able to? Now, a comprehensive estate plan covers contingencies not only for you, but also for any of your minor children. Now, a delegation of parental authority, or DOPA, is often called the power of attorney for parents or parental POA. It allows you to give a non parent the legal authority to make certain decisions for your minor child. Delegating your parental authority to another person in a legal document can help ensure that your child receives the care they need when you're out of town, on business, or on vacation. The document typically does not require a court order and it does not supersede your parental rights. So, up until a certain age, your kids rely on you for just about everything. You might not realize just how much they depend on you until you're not there for them. Even when you leave the kids with the babysitter for a short period, it can quickly become apparent from the long list of instructions that you provide just how important tasks and details a parent is responsible for daily. As kids grow older and become more and more independent, they often require less from you. However, until your child reaches 18, you are legally responsible for their well being. And there are some things, such as receiving medical treatment or entering into a contract, for which a minor child must obtain parental permission. A DOPA, or parental power of attorney, is a document that temporarily allows someone else, known as the agent or the attorney in fact, to care for your child and act on their behalf similarly to the way that you could. This tool is commonly used when a parent is leaving the state or country for a personal or work trip, or when a parent is facing incarceration, military deployment, long-term medical treatment, or risk of deportation. This document does not override or interfere with your parental rights regarding the care, custody, and control of your child, but it does permit a caregiver to act in your stead on important matters like taking them to the doctor, excusing them from school, attending and consenting to school activities, inspecting and obtaining their records, and making decisions during an emergency. Not having a DOPA or a parental POA for your minor child could mean that crucial care could not be provided in a timely way or even at all in your absence. It could also mean that in an emergency, the school or some other authority could make a choice based on their policies and procedures about your child's care that you just may not agree with. Let's talk about how a DOPA works. The legal form you use to give quasi-parental rights to a third party may go by different names in different states. State law can also vary on the specifics of how the document works. Some states limit a DOPA to a maximum of 6 months from the date it is signed, after which time a new agreement must then be signed. In other states, a DOPA is good for up to 1 or 2 years. States may have different requirements for completing and validating this document. State law requires a DOPA to be notarized before it takes effect, and there may be a requirement to inform the other parent about the agreement, with limited exceptions. If the person who's going to be caring for your child lives in a different state, you may need to fill out a DOPA form in that state as well. Now, despite these differences, DOPAs work similarly in most states, and they do share some pretty common traits. A separate DOPA needs to be filled out for each and every minor child. You can withdraw that power that you've given somebody at any time. The person that you named as an attorney in fact can be any adult. They don't have to be a family member or even a U.S. citizen. Now, this power of attorney does not take away your right to make decisions for your child. You can still overrule a decision made by that attorney in fact. And another one is that they're just not transferable. So these power of attorney forms typically state that the attorney in fact has all of the power and authority that the parent or guardian has, set the power to consent to marriage or adoption. They also provide the option for a parent to delegate to the attorney-in-fact only specific powers and responsibilities that are listed in the document. Now, there's some other considerations for a parental power of attorney as well. The person you choose to make decisions for your child should be someone you know very well and trust. But it may be worth asking if they would make the same choices that you would make and the types of situations that could come up. You cannot expect your attorney-in-fact to be completely aligned with you on every conceivable scenario. While they will probably be able to check with you about a non-emergency decision, they will still need a degree of autonomy to act independently and exercise their best judgment if something unexpected happens and you cannot be reached right away. Choosing a close friend or family member or neighbor or another responsible adult with whom you share similar values can help ensure that you're in accord about the most important issues. The person that you choose should be somebody your child is familiar with and comfortable around so that your child is receptive to their care and authority. Discuss the appointment of the short-term caregiver with your child and talk about your upcoming trip with them. Extended time away from a parent can be difficult for a child. Establishing expectations and a schedule of how often you will check in, both with your child and the caretaker, can keep everyone on the same page and ease the apprehension surrounding your absence. You know your kids best, though, and frequent check-ins might make them more anxious. In addition to emotional considerations, there are some practical points to keep in mind as you get ready to embark on this trip of yours. You want to talk to schools and doctors and banks and other individuals and organizations to make sure that they recognize and accept the power of attorney. You want to double check to make sure that that definitely is the case before leaving. And I mean double check. Your child's doctor or school may have their own forms that are needed to access records or to pick them up from school or to authorize care for them. You also want to make copies of this power of attorney so that the attorney-in-fact can give them to the authorities who might need proof that they're in charge of your child. You want to also keep a copy for yourself and also estimate ahead of time how much it will cost to care for your child while you're away and ensure that there are adequate funds to pay for these needs. You may want to give the caregiver money up front or leave them with one of your credit cards. Now, the attorney-in-fact should also have some particular information about your child. So the school name and phone number, the teacher's name, the medical insurance information, the names and phone numbers of your healthcare providers, whether or not they have any allergies or if they take any medicines, also their daily routines and activities, and their contact information for friends and parents, and also for your other family members if anything should happen to you. Now, your profession and travel destination and the type of your trip also need to be communicated because these things might put you at risk. Now, the U.S. government encourages travelers to high-risk areas to enroll in the State Department's Smart Traveler Enrollment Program. Develop a communication plan with all of your loved ones and discuss a plan with them about the care and custody of your children. You also want to make sure that you have an up-to-date estate plan. Now, traveling out of town when you have children can be stressful for them and you. Now, there's no substitute for a parent's love and care. We all know this. But if work or other circumstances keep you away from your children, that parental power of attorney or DOPA might be the next best thing. A comprehensive estate plan should also cover a permanent guardianship arrangement for your children on the off chance that a worst case scenario unfolds while you're away. Part of estate planning is thinking about what could happen to you and putting measures in place to protect your family. Your current estate plan may not address child care and guardianship issues, or you might need to make updates to your plan to reflect current circumstances, such as the birth or adoption of a child, divorce, or nominating a new guardian in your will. You cannot protect your children from everything, but you can leave as little to chance as possible with a well thought out estate plan. So if you need to create or update your plan, just contact your local qualified estate planning attorney to help you put these plans in place. I want to thank you for watching. Please like and subscribe to learn more about estate planning. I'm attorney Kelly Longtin from Kelly Longtin Law.